Hello, everybody, and welcome to our legal landlord law cases webinar, which is when we invite a barrister who has been one of the barristers in a significant case to talk to us about it and explain it. And today I'm delighted to have barrister Justin Bates, who is from Landmark Chambers, who is going to talk to us about the very important case of Rakusen and Jepson, which is about rent repayment orders. So welcome, Justin.
Hello, nice to speak to you again. I would say see you, but we both turned our cameras off, so we can't see each other.
Yeah, we don't have the cameras because it might affect the broadband, and we don't want it to go down. There is the ability for you to sort of chat and ask questions, but I will only put the questions to Justin if they are relevant on the case. So we're not here to answer people's problems. We're discussing the case. So take it away, Justin.
Right, let me just move my keypad around. There we go. Right, so yeah, I'm going to talk for, I guess, 20-25 minutes about a case called Rakusen and Jepsen, all about rent repayment orders. The first time the Court of Appeal has looked at rent repayment orders, whether under the Housing Act 2004 or the Housing and Planning Act 2016. There have been upper tribunal cases on both the 2004 Act and the 2016 Act, but this is the first time the Court of Appeal got to have a look at it. And that's quite important because the Court of Appeal tells the upper tribunal and the first tier tribunal what the law is, and one of its jobs is to try and sort of set the direction of case law. Oh, I have an echo, says Mike Illingworth. I wonder why that is. Can you hear an echo in me, Tessa?
I can't hear an echo, but I will mute myself in case it's coming from my end.
Ah, okay. Yeah, so one of the jobs of the Court of Appeal, aside from just correcting errors of lower courts and tribunals, is to sort of set the direction of the law. The Court of Appeal hears a couple of thousand cases every year, and its job is to try and give a steer, a general guide to lower courts and tribunals about which way the law should be going on certain questions. So, let's have a little bit of a background and a history lesson about what rent repayment orders are. They're created by the Housing and Planning Act 2004, and then in England they're expanded by the Housing and Planning Act 2016. The Housing Act 2004 is still the position in Wales, although Wales has also developed a bespoke sort of Welsh-only form of repayment order under the Housing Wales Act 2014. To the best of my knowledge, there was never an upper tribunal appeal on a 2004 Act repayment order from Wales, and there definitely hasn't been anything significant on repayment orders under the Housing Wales Act. The reality is this has been an English tool, and it's England that's developed most of the case law. Now, the 2004 Act created a mechanism whereby if a landlord had been convicted of a particular housing offence, mainly to do with licensing, then after conviction you could apply as a tenant or as the local authority in respect of housing benefit, you could apply to the first tier tribunal for an order or providing for some or all of the rent to be repaid to you. It was kind of an additional penalty above and beyond the sanction imposed for conviction. To be perfectly honest, repayment orders under the 2004 Act didn't really go very far. Firstly, they didn't apply to very many offences. Secondly, it was a requirement that you actually had a conviction before you could apply for a rent repayment order. And although you occasionally see high-profile examples in the local press, there aren't really many local authority housing housing prosecutions that are brought. And the third problem was a structural one as to how the Act was written. You could only go back and get 12 months repayment of rent from the 12 months back from the conviction. So if you were a really, really dodgy landlord and you were faced with the possibility of a rent repayment order, it made sense to plead not guilty to the criminal charge, even if you were as guilty as sin, because the longer that it went on, the lower the amount of the rent repayment order that could be paid back. Because it was only 12 months from conviction. And if you hadn't been receiving the rent from these people in 10 of those 12 months, you could only therefore repay 2 months' worth. Thanks, Tessa, for checking that. So just to say for those who are perhaps following this later, because I know it's being made available online to watch later. One person can't hear us, and Tessa's just checked everyone else can hear me, which is good. So the 2004 Act was a bit of a dead letter. The 2016 Act was intended to expand the scope of rent repayment orders and revitalise them slightly. It still applies where the landlord's been convicted of a relevant housing offence, and we'll come to what that is in a moment. But, and this was the big change, a conviction isn't a prerequisite anymore. You can get a rent repayment order without a conviction if the tribunal is satisfied beyond reasonable doubt that the landlord had committed the offence even though there is no conviction. So you don't have to go to the magistrate as a local authority and convict someone of the offence. Instead, the tenant can apply to the first tier tribunal, and if they can prove that you have committed the offence, albeit you haven't been convicted, then they can have their rent repayment order. And the rent repayment order is still 12 months worth of rent. You got round the problem of it being 12 months from the date of the conviction by introducing this new option of going not even where there isn't a conviction. So the three changes were, firstly, you'll see in a minute, the scope of what the relevant housing offences was extended. Secondly, you don't need a conviction anymore. And thirdly, you can't, as a landlord, just game the system by pleading not guilty and letting time drag on, because you don't need a conviction anymore. So it was intended to be quite a big change. A, empowering tenants to go by themselves, and B, increasing the amount of money that was available to claim on a rent repayment order. Now, previously, under the 2004 Act, the RROs were only available for items 5 and 6 on that list, but now, as you can see, there are 7 different scenarios in which a rent repayment order can be made. The first 2 are, in very simple terms, the unlawful eviction offences. If you, as a landlord, use violence to secure entry, or if you unlawfully evict or harass your tenants, then a rent repayment order can be sought. Those, as a basis for RROs, those are comparatively rare in my experience. The third and fourth relate to housing conditions. If you fail to comply with an improvement notice or you breach a prohibition order, then a rent repayment order can be made. Failures to comply with improvement notices are relatively common, sadly, but RROs for that are perhaps less common. I suspect the reason being the tenants tend to leave where the property is in such bad condition, and that they're not really thinking about getting their rent they paid back. They just want to find somewhere else to live. The 5th and 6th offences are the most important ones because they're the easiest ones for a landlord to commit. If you are in control of or managing an unlicensed HMO or an unlicensed Part 3 property, effectively a house that isn't an HMO, then a rent repayment order can be sought. The 7th one hasn't happened yet because there aren't that many banning orders in the first place, and I'm only aware of one person who's been prosecuted and convicted for breach of a banning order. So it's 5 and 6 that matter, and they are the key ones because it's relatively easy for a landlord to commit the offences of operating or controlling or managing an unlicensed HMO. And because you don't need a conviction anymore, you just go to the tribunal and you prove that we are an HMO to which Part 2 applies, no licence has been attained. That's enough to get you over the hurdle to get an RRO made. Similarly, Part 3 properties, you Similar way, am I a Part 3 property? Yes. Have you got a licence? No. Then an RRO can be made. It's important to remember, of course, that both those licensing offences are what's called strict liability. Landlords don't have to intend to have operated an unlicensed property. It's you either do or you don't. It's a binary state. If in fact your property needed a licence and you didn't have it, you commit the offence, and therefore the RRO can be made. And there have been lots and lots of RRO applications made on the basis of 5 and 6, made by tenants against their landlords. And there are various organisations that have sprung up to assist tenants in making those kinds of applications. And as you can appreciate, 12 months rent, which is the most you can have back, is potentially quite a lot of money to recover. So who can you make an RRO against? And this is really what the Rakusen and Jepsen case is about. Now, under the 2004 Act, no one had really bothered with this question, because under the 2004 Act, it was absolutely clear. You could only make an RRO against an immediate landlord. So, sorry, someone's asked, could I explain number 6 a bit more? Yeah, back there. So number 5 is unlicensed HMOs. So HMOs are governed by Part 2 Housing Act 2004, and that's where you've got more than a certain number of people who are unrelated to each other who live in a household. Offence 6 is exactly the same, but for non-HMO properties. Because Part 2 governs HMOs, Part 3 of the Housing Act 2004 governs non-HMOs. It's the selective licensing properties. So if a local authority chooses to introduce a selective licensing scheme for its area, then you might need a license, even if what you're renting isn't an HMO. So the most obvious example would be, suppose you decide to rent a house to a family of 2 adults and 3 kids. That's not going to be an HMO. It's enough people to pass the HMO test, but they don't form 2 or more households. So it's not an HMO, so it can't be a Part 2 HMO licensing question. But if your local authority has a selective licensing scheme under Part 3, then that's probably going to be a Part 3 property. And so it's going to need to be licensed even though it's not an HMO. That's the difference between Part 2 licensing and Part 3 licensing. Part 2, HMOs. Part 3, other licensable properties that are not HMOs. But they are exactly the same in terms of how you apply, in terms of the test for whether you get a license, and importantly, they're the same for licensing purposes on RROs. If you've got a property that has to be licensed, whether under Part 2 or Part 3, and it does not have a license, then you commit a criminal offence, and you are liable to have an RRO made against you. You do not have to intend to commit the offence. If your house needs a license or your flat needs a license and it doesn't have one, you commit the crime. And that's, as you can see, that's why 5 and 6 are so important, because they're really, really easy offences to commit. And there isn't much you can say as a landlord in defence. If it needed a licence and it hasn't got one, then that's the end of it, really. So, just back on this for the moment. Who can you make an RRO against? Under the 2004 Act, there was never a question about this, because the Act dealt with this. It said you could only go against the immediate landlord. So imagine you've had the following scenario. Imagine you've got a house, and you've got the freehold of the house. You grant a 5-year lease of the whole house to me, and the terms of my lease allow me to sublet. And then I grant tenancies of each individual room. That is almost certainly going to be a licensable property, whether under Part 2 or Part 3, probably Part 3 on that scenario. Maybe Part 2. Anyway, it's going to fall within, that scenario will definitely fall within one of Part 2 or Part 3. If I don't get a licence, I commit a criminal offence. And therefore, under the 2004 Act, if I was convicted of that offence, you were entitled to apply against me as the tenant's landlord to have the RRO made against me. Now, the 2016 Act changed this. And the question is, what was the effect of that change? Because the 2004 Act kept talking about the landlord and the immediate landlord. And the 2016 Act used different language. It said you could make an RRO against a landlord, and then in a different part of the Act, it said the landlord. Now, does the introduction of the power to make it against a landlord mean that you can go against any landlord, or is it just a bit of bad drafting by Parliament, and was the intent to always go against the immediate landlord as it was under the 2004 Act? Why does this matter? Well, let's go back to our example. House owned by you. You grant a 5-year tenancy, not to me this time, but to a company that I control. My company is a limited company with a share value of £1, because I am not stupid and I am not going to keep lots of money in my company. My company then sublets each individual room to occupiers. You, as freeholder, you don't go and get a license because you think, well, why should I? I've rented it for 5 years to Justin's company. I don't go and get a license, whether because I'm ignorant or because I'm dodgy. An offence has clearly been committed there. Almost certainly by me, possibly by you as well. It depends upon the terms of the rent, of how the rent is paid, but certainly by me. Assuming that the tenants want to go and get an RRO in those circumstances, there isn't really much point the tenant going for an RRO against my company, because my company is worth £1, and I can assure you it will not keep the rent from the tenants sitting in a bank account they can find. It will disperse that rent as soon as it receives it. It will disperse it on paying me, because it's my company. It will disperse it on paying its bills. So, by all means, go and get an RRO against me, against my company. My company is worth £1, so you can have £1, and if you want to get any more than that, you can wind it up. And it won't give you any money, because it hasn't got any, because it's structured not to hold any money. Moreover, the lease that it holds isn't really worth any money, because a 5-year lease isn't really an asset in that sense. So you aren't ever going to get any money off me in respect of my criminal activity. That makes RROs kind of pointless in those circumstances. So, wouldn't it be better, from the tenant's point of view, if you could get an RRO against the freeholder, i.e., in our scenario, against you, all of you listening to it? Because you are a landlord, and the Act now says a landlord. You are a landlord, and my company is your tenant. Parliament changed it from the landlord to a landlord. It must have done that for a reason. It presumably did that to encourage people to go and get RROs against the true owner of the property, where the intermediate owner wasn't worth pursuing. Now, that scenario that I've just described, most of you will know is called a rent-to-rent scenario. Rent-to-rent is lawful and in many cases wholly legitimate. It is, however, capable of significant exploitation. And there is undoubtedly a sector of the a part of the private rented sector which exploits the rent-to-rent model for the purpose of frustrating the legislative protections designed to benefit tenants. And there are two basic models of dodgy RRO. One is to have a company worth £1, because if it does anything wrong, you can just wind it up and there'll be no consequences. The other is to have a confusing series of intermediate human tenants. So you'll see this a lot, particularly in flat shares, it has to be said, in our big cities, where you have this concept of the head tenant, who is apparently the tenant of the whole unit, and then the head tenant sublets individual rooms to others, and the head tenant collects the rent from those people and passes it back to the landlord. There's nothing unlawful per se about that, but it is a model that is capable and is used by many, many dodgy people as a way to try and frustrate landlord licensing and frustrate tenants' rights. And if you want to read about it, the Safer Renting report that I note at the bottom of that slide, there's a link to it at the very top of the chat box. Safer Renting, Ben Reeve Lewis's organisation, who many of you may know, they've done quite a lot of work on this with an academic at York, I think, called Julie Rugg, and they've done quite a good analysis of the scale of the abuses of the RRO sector. You will immediately appreciate that RROs can be rendered pretty pointless if you are a dodgy landlord who wants to use this intermediate model. Tessa, you're about to come in here, aren't you?
I was just about to say, for people listening to the recording, we will put a link to the Safer Renting report on the YouTube version of the recording. So if you're listening to it, you will be able to find it there.
That is a very good point, because I forgot we were going to record this. Goes up online afterwards, and that would absolutely baffle anyone who was sitting there going, "What is he talking about?" So that's the history of them, and the rent to rent model is this kind of emerging problem that looks like it's going to undermine a lot of the 2016 Act changes. Now, there are two cases about how RROs work with rent to rent schemes. The first is a case called Goldsborough and CA Property Management. Let me just say, for the benefit of ensuring I am not sued for defamation later on, I have absolutely no reason to believe that there was anything dodgy going on in this case at all. Rent to rent is a lawful and legitimate business model, and I have no reason to believe it was anything other than lawful and legitimate in this case. Now, in this one, it's a fairly simple scenario. You've got the head landlords, Mr. and Mrs. Gardner, you've got a 5-year lease to CA Property Management, and then you've got the subtenants, Goldsborough and others. This was an unlicensed HMO, absolutely plain as a pikestaff. It's an unlicensed HMO. Sorry, 1 minute. Have a glass of water. And because it's an unlicensed HMO, the tenants want their rent repayment order. They decide to go against the Goldsboroughs because CA Property Management isn't worth any money. It's a £1 company and it's only got a 5-year lease, so the lease isn't a valuable asset either. And the Goldsboroughs say, whoa, what are you talking about? We rented this out to CA Property Management. CA Property Management is your landlord. That's who you've got to go against, not us. And the Upper Tribunal says no. The Upper Tribunal says it's really, really important to note that Parliament changed the language from the Housing Act 2004 to the Housing and Planning Act 2016 and changed it from the to a. And you are clearly a landlord. It doesn't say, the Act, that it's limited to the immediate landlord of the tenant. It just says you can make them against a landlord. So, therefore, we can get it against you. Sorry, Tessa, could I mute you because I can hear myself coming back?
Sorry, I just wanted to say, you said that it was brought against the Goldbergs. It was actually brought against Mr. and Mrs. Gardner.
Sorry, Gardner. Sorry, you're quite right. Sorry.
Just thought I'd clarify that.
Sorry, yeah, they went against the Gardners as the head landlord. Sorry, and the Upper Tribunal says, look, there's been a change of language. That change of language is important, and that's the reason. Now, there's not a lot of reasoning beyond that in the Upper Tribunal's decision. The judge in question just says, I've got the 2004 Act in my left hand, I've got the 2016 Act in my right hand, the wording is not the same, there must be a reason for that. The reason would seem to me to be that you can get it against more than one kind of landlord. One of the things that troubled lots of lawyers when this case came out is that there wasn't really very much argument against that being put forward. From memory, this was a case where both sides did it in person. They didn't have lawyers acting for them. And that's a common problem, it has to be said, in lots of these FTT and Upper Tribunal cases. And it means that arguments that could be run aren't run. And where that's not that big a problem in the FTT, it is a problem when you get to the Upper Tribunal, because the Upper Tribunal makes law. So all FTTs in the country have to follow what the upper tribunal says the law is. So if the upper tribunal gets it wrong, the FTT still has to do what the upper tribunal says the law is. And that's one of the things that sort of broader point troubles me about this tribunal-based regime for regulating the PRS. There are not enough lawyers involved in it because the tribunal doesn't allow you to recover costs, which means that getting lawyers involved is often uneconomic. I understand that on an individual level, but it causes a problem for the development of the law. Because this was a pretty controversial case when it came out. I have to say, I'm not sure many people thought that that was the obvious intention of Parliament in changing the language. I'm not sure many people thought the change was that important. Anyway, that brings us to Rakusen and Jepsen, finally, which is what the case is actually about. Rakusen and Jepsen, very, very similar scenario. Rakusen, as the head landlord, property investment company, has got a 3-year lease, and it's always intended that there's going to be subletting because the lease permits it, and then you've got a series of subtenants. As with the previous case, I have absolutely no reason to believe there is anything dodgy going on here at all. In fact, to the contrary, I actually suspect this was a very, very legitimate and sensible rent-to-rent model that was being set up. So please don't anyone suggest that I'm defaming anyone involved in this case. I think this was an even more legitimate model than the one we talked about previously. Anyway, it was an unlicensed HMO. So the tenants decide to try and go for an RRO against not their immediate landlord, because there's no point going against the property investment company because it's got no money and it's only got a 3-year lease. So even less valuable than the 5-year lease previously. And they say, look, it's been decided by Goldsborough that I can go against a tenant. Sorry, I can go against a landlord, sorry. You are a landlord, therefore I want to have an RRO against you. And Mr. Rakusen says, well, Goldsborough is wrong. It is just wrong. That is not the law. Parliament wasn't intending to change things. The upper tribunal got it wrong. He loses that argument in the first tier tribunal because, as I explained earlier, the first tier tribunal has to do what the upper tribunal says the law is. So the FTT says, well, we're very sympathetic, it's a good argument, but this point has been decided by the upper tribunal. It is simply not open to us to say the law is something else because they are a higher level tribunal than us, so we must follow what they say. But they gave him permission to appeal because in the upper tribunal judges are allowed to disagree with each other. So the upper tribunal judges don't have to follow what another upper tribunal judge has said. They do normally, because as you can imagine, if they all disagreed with each other, that would be chaos. But they are, as a matter of legal theory, allowed to disagree with each other. But in this case, they didn't disagree with each other. Martin Roger QC, who's the deputy president, he agreed with what Judge Cook had said in the earlier case. He said, well, she gave one reason, which is the Act says a landlord, and she's right, it does say a landlord, and you are a landlord. But he gave 2 other reasons as well. And he said, well, look, go back to all of these offences here. Have a look at all of them. Because I know we're only looking at offence 5, but look at all of them. Every single one of those offences can be committed by both a head landlord and by an immediate landlord. So that would suggest Parliament didn't have a particular problem with the idea of penalising head landlords as much as intermediate landlords. Because the head landlord could decide to unlawfully evict someone, the head landlord could decide not to comply with local authority notices, and the head landlord could fail to be licensed, and it could breach a banning order. None of those are limited to immediate landlords. And the third thing he says is this. He says, well, look, I as the deputy president of the upper tribunal, I spend a lot of time dealing with appeals about this. And I know that there is a problem with a very dodgy rent-to-rent sector in parts of England. If you couldn't get an RRO against the head landlord, if you were limited to the immediate landlord of the tenant, then that's a massive encouragement for the dodgy players in the rent-to-rent sector. Because they'll just set a company up worth £1 with no assets apart from a very short lease. And now there's nothing you can do to them. because you'll never get the RRO. And it's the RRO that's the best remedy for a tenant. So if you can't do this, Parliament has created this enormous loophole that the dodgiest part of the market will try and exploit. So therefore, he says, for those three reasons, Goldsborough is right, and you can go for an RRO against anyone. But the landlord, not to be deterred, appeals to the Court of Appeal. And the Court of Appeal is also where I come involved, because Safer Renting, who are a charity who specialise in supporting tenants, apply to what's called intervene in the appeal. So just diverging here for a minute. Most litigation is A against B. It's landlord against tenant, it's driver against person they crashed into, it's person who was injured by the NHS against the NHS, etc., etc. When you start getting cases going up to the Court of Appeal and the Supreme Court, because part of the role of the Court of Appeal and the Supreme Court isn't just to decide individual cases, but to decide big questions of law and give lower courts and lower tribunals a steer as to the approach they should take, you sometimes get what are called interveners, which are people who are not part of the case, but who are affected by the issues involved in the case. So, to give you some examples, whenever there are big homelessness cases in the Court of Appeal, you often get Shelter intervening, and they try and explain how the effect of this decision is playing out across the country. In lots of big welfare benefit appeals, where it's the benefit recipient against the local authority, the Secretary of State intervenes, because the Secretary of State is ultimately responsible for paying the benefits bill. The right to rent litigation that some of you may have heard Tessa's webinar about that I did a couple of years ago, there were lots of interveners in that. I was for the National Landlords Association, trying to explain how right to rent affected landlords, but Liberty and other human rights groups intervened, trying to explain that. So you get the idea. It's people who bring a broader perspective, and it's to try and make sure the court understands the whole policy area that it's dealing with. So Safer Renting intervene, and they intervene to do two things. They intervene to explain what the policy development of the 2016 Act was, and they intervene to give examples of really dodgy rent-to-rent scenarios where it is absolutely clear that the rent-to-rent model is being used by landlords to protect themselves against regulatory regimes and for the purposes of avoiding tenants' rights. So, Court of Appeal, hear the appeal. And the argument for the landlord is, under the 2004 Act, it said the tenant, so the landlord, it was always intended to be the immediate landlord. Nothing changed in the 2016 Act. The argument for the tenant is there was a change of language, the language is important, and the argument from Safer Renting is if you decide that the landlord is right, you need to be aware that what you will do is open the doors to dodgy practices in the rent-to-rent sector. And so the Court of Appeal hear this argument over a day's argument, and then they take time to consider it. And they come back and they allow the appeal. They say the landlord is right. They start off by saying that they agree with Safer Renting that the purpose of a rent repayment order, as part of the wider regulation of the private rented sector, is to do one of two things. The trend of regulation in the private rented sector, says the Court of Appeal, is to do two things. It's to force landlords to raise standards, or it's to force them to leave the sector. And they don't really think there's any doubt about this. If you read all the policy documents, they think when you look at it, whether it's this or whether it's restrictions on Section 21, that's what Parliament's intent has been for the last 10 years or so. You meet certain standards, or we will do our best to drive you out of the sector. But, says the Court of Appeal, that only gets you so far. Because you've actually got to read the words of the Act and see what the Act actually says. It talks about a rent repayment order against a landlord. Well, what's a landlord? I mean, let's go to the dictionary. And the normal definition of landlord is the immediate landlord, the person who has rented you the land. Of course, a landlord can be anyone in the chain, but in other legislation where Parliament has wanted to catch head landlords and landlords elsewhere in the chain, it's used a different kind of wording again. And it hasn't used that wording here. It's just changed the to a. And that doesn't seem to us, said the Court of Appeal, to be enough to indicate that Parliament was trying to take a radically different approach. If Parliament was trying to catch any landlord in the chain, it should have used different words. Secondly, said the Court of Appeal, you need to remember a point no one had made until the Court of Appeal. The Court of Appeal said, look, this is penal legislation because it imposes a penalty on a landlord who may not have done anything wrong in a morally blameworthy sense. And there's nothing wrong with penal legislation. All criminal law is penal legislation. But there's a rule of law that where legislation is penal and where it's capable of being read as having two meanings, you should adopt the meaning that is most favourable to the person being penalised. It's what's called the presumption against doubtful penalisation. So you've got two readings of this. One is immediate landlord, one is any landlord. Because it's penal, you adopt the most charitable interpretation, and the most charitable interpretation to the landlord, because he's the person being penalised, is that it should only be immediate landlord. The Court of Appeal then end by saying, we do recognise that we've just created a problem for the dodgy end of the rent-to-rent sector. We do recognise that now the effect of our decision is that you set a £1 shell company up and you can largely be protected against the effects of the RRO regime. We can well understand, they said, that Parliament might think that's a really bad thing for us to do. But if Parliament thinks we've got it wrong, Parliament should change the law. It's not for us to take what they consider to be quite a strained reading of the Act to achieve a societal good. It's for Parliament to write better legislation. So we may see this coming back in the Renters Reform Bill, if that ever surfaces, as something to look at in the future. So, two conclusions, and then one bit of breaking news I'll pass on to you. Two conclusions from it. The narrow point, and the bit I suspect most of you listening to this care about, is that RROs can't be made against head landlords. You can only go for an RRO against the immediate landlord. That is an enormous boon for the rent-to-rent sector, the legitimate and the dodgy end. It's a huge relief to people that run legitimate rent-to-rent models, and it is a huge relief for people that run dodgy rent-to-rent models. The broader point, the second point, is this. You'll have seen the landlord lost in the first tier tribunal and he lost in the upper tribunal, and then he had to go to the Court of Appeal to try and win it. The lawyers for the landlord deserve enormous professional kudos for this, because it's never fun. As someone who loses a lot, I can assure you, it's never fun losing. And they got pretty badly battered in the judgments in the FTT and the upper tribunal. I mean, it wasn't, those two tribunals didn't think it was close. They thought it was very straightforward what the answer was. And having the nerve to push it is an important part of being a very good lawyer. But it also shows you, for those of you involved in this, if you get involved in litigation, one of the things you sometimes need to be aware of in litigation is that you're going to have to push it knowing that you will lose, because you've got to push it to a stage where you can get the result you want. Once the Goldsborough decision came out, you were never going to win this point in the first tier tribunal. It was impossible to do so. In reality, whilst it's technically possible to win it in the upper tribunal, the upper tribunal doesn't like disagreeing with other upper tribunal judges, so it was going to be a hard one to try and win there. This probably wasn't capable of being won until they got to the Court of Appeal. And it took a lot of skill and a lot of nerve from the landlord as well to push it up there. I don't mean nerve in a bad sense. I mean like keeping his nerve to push it up there. This may not be the end of the story, because it appears very likely that the tenant will appeal to the Supreme Court. That doesn't mean the Supreme Court will hear the appeal. The Supreme Court has to decide to give you permission. The Supreme Court only hears between 40 and 50 cases a year, and the Supreme Court will generally only hear cases of national importance. For my part, I think this is sufficiently important to justify going to the Supreme Court, because it affects potentially tens, if not hundreds of thousands of properties across the country. And I think the Court of Appeal's conclusion, whilst I understand the legal logic of it, in policy terms, I think it's disastrous because it's made life an awful lot easier for the dodgiest players in the sector. So it may be this isn't the end of the world, end of the road, sorry. It may be the Supreme Court decide to have a go with it. If the Supreme Court do decide to have a go at it, I'll come back in a year and a bit's time and tell you what they said, because it'll take about a year to get it into the Supreme Court. But for the moment, the headline point and the point for that most of you in this are going to be interested in is that if you have a situation where there is an intermediate landlord, then it is only the intermediate landlord who can have the rent repayment order made against him. Let us see if Parliament or the Supreme Court want to have a bit of a go at overturning that. Tessa, I was going to stop there for a bit because my last two slides just say questions and thank you for listening. And I've talked for 40 odd minutes already. So shall I stop there? Is there anything you want to talk about coming out of what I just said?
I suppose the only thing that occurs to me is that if it had gone the other way, then there's the possibility that the head landlord will have to pay back rent that they haven't actually received because the rent's gone to the immediate landlord, and it is supposed to be a rent repayment order. So how can they repay it if they haven't had it?
Well, they've received some rent, just not from the tenants, because of course the rent goes down the chain, doesn't it? In practice.
Yeah. Yeah, but I mean, they may not have done. I mean,
they may not have done. I mean, it would be an odd situation where the landlord, where the freehold owner grants a 5-year lease to the company. The company then lets it on what the lawyers call the rack rent. So for everybody else, the market rent, and the freehold owner doesn't take most of that rack rent. That would be a bizarre business model. But yes, I agree. I mean, there are certainly scenarios where a potentially unfair result could arise. Now, we touched on that in the Court of Appeal, and on behalf of Safer Renting, we identified that as a potentially unfair scenario, and we said, well, we don't actually think it would arise. One, we don't think it's very likely, but two, if you're in those circumstances, so the rack rent is being held by the intermediate landlord, and you as freeholder are only getting some nominal rent, you probably aren't managing or controlling an HMO. Because remember, the definition of control and management looks at who receives the rack rent. And if you receive less than 2/3 of the rack rent, you can't be controlling or managing it. So if the landlords, the true landlords, were only receiving 50% of the rack rent, they couldn't be controlling or managing, which means they couldn't have committed the offence of having an unlicensed HMO.
I mean, what I meant really was, if you're looking at the dodgy end of it, often a landowner is seduced into setting up a rent-to-rent arrangement with a dodgy rent-to-renter, who then takes all the money and pays nothing to the head landlord. Now, if he's then ordered to pay a rent repayment order when he's had absolutely nothing.
I agree. Yeah, I can see that. It would be wrong to think that the dodgy people all act with the support and connivance of the true landlords. It is certainly possible for the dodgy people to exploit both tenants and the true landlords. That is certainly true, and that is a point, I suppose, that goes against what we were arguing for and what the Upper Tribunal said. That's a point in favour of the Court of Appeal's approach to it.
I think that's a point that would occur forcibly to many landlords.
Well, I think the answer I would say to that is that landlords are in a much better position to protect themselves than tenants. I mean, this comes back to a discussion you and I had with Ben a year and a bit ago.
Another Ben.
Another Ben. The reality is that landlords as a class are more powerful than tenants as a class. That is not the same thing to say that each individual landlord is powerful, but as a class, the landlord is the more powerful player. And the landlord, again, if he's going to have one of these rent-to-rent models, there are things he can put in place to protect himself. There's nothing to stop him requiring a chunk of the rent to be paid up front. Nothing to stop him requiring a chunk of money to be held in an escrow account, for example. He doesn't have to trust the people that he's going to rent his property to for 5 years. Whereas by contrast, because the tenant must find somewhere to live, they just are less powerful. They have less bargaining power in the market. There are more tenants than there are properties. That's why rents go up.
It's very difficult.
It is. I mean, again, comes back to what you and I and Ben were talking about 18 months ago. What you need is more housing.
Just to let people know, I run a podcast, the Landlord and Lawyer podcast with Ben Beadle, and Justin was our guest. I'll put a link to it in the YouTube, place where the recording goes. But yeah,
I completely accept that. I mean, I have acted for landlords who've been on the receiving end of very dodgy rent-to-rent companies, and getting them out of the mess they get involved in is both time-consuming and expensive. There are plenty of people who use property as a way to make a quick buck, and they don't really care who they hurt.
Yeah. Well, it's thank you very much, Justin, for a fascinating talk. And no doubt, if the permission is granted for the Supreme Court, you'll be coming back again to tell us what happens.
Well, I mean, I think if permission gets granted, I think you'll see quite a lot of people intervening in it. I would expect the Secretary of State to intervene, to tell us what he meant to do when he changed it from the to a. Did he actually intend there to be a difference? So.
Okay, right. Well, I think we better close down now. Thank you very much, Justin, for coming along and explaining it to us. And as I said, this will be going onto our Landlord Law YouTube channel, and I will also put it on the Landlord Law blog as well, so people will also be able to find it there.
Do you want me to pick up on some of the questions we've got here? Because there's some general ones here that we can spend a couple of minutes on. Yeah. So there's one question about, would it help the rent if the true landlord had a clause in his agreement saying the rent-to-rent company is responsible for licensing? Sort of. I mean, one of the things that is really, really underexplored in rent repayment orders, and indeed in licensing generally, and one of the things that the upper tribunal is absolutely crying out for us all to explore a bit more. I mean, Martin Roger could not make it more obvious that he wants people to run this argument. Is he wants everyone to think a lot more about the reasonable excuse defences that exist for landlord licensing. Because whilst landlord licensing is a strict liability offence, i.e. you commit it if you haven't got a licence, there is a defence of reasonable excuse. And Martin Roger, who's the Deputy President of the Upper Tribunal, is dropping some really big hints that he wants people to run reasonable excuse defences because he wants a chance to think about them. And he's suggested, for example, in some of the cases that he's dealt with, he's suggested that if you had a reputable agent and the agent just let you down, that would be a reasonable excuse. He has suggested that where if you didn't know about the requirement to get a licence, that would be a reasonable excuse.
There was a case on that. There was the case where the local authority said that they'd tell this woman, and then they didn't tell her, and they also helped the tenants bring a claim for a rent repayment order.
The Tower Hamlets one. Yeah, the Upper Tribunal had no real difficulty finding that was a reasonable excuse. If the licensing authority writes to you and says, "We will tell you if you need a license," then they don't tell you and try to prosecute you. They didn't really find that a very difficult one. The Upper Tribunal is really, really interested in the reasonable excuse defence, and it couldn't make it any more obvious that it wants people to run that more, so it can figure out what the scope of the reasonable excuse defence is. Second thing would be, would it assist you? Possibly. I mean, if you made it, if you as head landlord made it a requirement of your contract with intermediate landlord that they have to do X, Y, and Z, or they have to indemnify you if X, Y, or Z happens, then you could sue them for damages, obviously, if they didn't do it. The problem is they're not worth any money. I mean, the real problem with rent-to-rent companies is that they are generally companies that are not worth any money. And if you contract with a company that isn't worth any money, you take your life in your hands. Because it's not about, there's no point having legal rights you can't enforce, and you cannot enforce your rights against £1 companies, and you have to be just have to be aware of that.
Yeah.
I mean that is just something you have to accept. Secondly, just to correct someone who's pointed out, they're right. I said, of course, it was all about our control for HMO purposes was whether it was on rack rent. And whether I said in Gutted it was 2/3, it's not. You can remind that 75% is the rack rent, not 2/3 rack rent. But the point is the same. If you're receiving the majority, in order for the true landlords to need to have their HMO license, they've still got to be controlling or managing. And controlling or managing is governed by the amount of the rent they're receiving as against the market value of the rent. So once they start receiving significantly below market value, they aren't controlling. Therefore, they couldn't commit the licensing offence. But that is a pretty sort of long-winded way of doing this. Another question: if the law does change, can head landlords again be held liable? So if the Supreme Court grants permission to appeal, and if it allows the appeal, then what it will do is it will say the upper tribunal was right and that is the law. What that means is anyone who's in a rent-to-rent situation then immediately faces the possibility of repayment claims if there's been a relevant offence. If the Supreme Court say that the Court of Appeal got it wrong, they don't change the law only from the date of their decision. The way it works is that's always been the law. It was just the Court of Appeal were in error. So you'd immediately need to start worrying about your rent-to-rent scenarios again. What happens if the head landlord is evicting the lower landlord for non-repayment? It depends. That's a very, very difficult question, and a lot depends upon what the position of the actual occupier is going to be.
Would that be a reasonable excuse?
If you were taking steps... So let's take this scenario. I've rented the property to you, Tessa. You, because you are a notorious crook,
thank you,
have unlawfully started subletting it and created an HMO. Upon discovering this, I take steps to end your tenancy and evict everyone. Yeah, that's a reasonable excuse. I had no reason to believe that what I'd let to you was licensable, and indeed it wouldn't have been. And upon discovering you were breaking the law, I took steps to regularise the position. Yeah, I say that's a reasonable excuse. I don't think that would be a proper basis for a rent repayment order. I feel fairly comfortable with that one. Yeah, I think so. I think then that is it enough for questions, isn't it?
Yes, I think so, and I think we ought to. I think we ought to close now. I mean, this just shows what a sort of quagmire this whole area is, you know, it's it's generally a really problematic area because there are proper arguments on both sides.
Yeah, and we'll see if the Supreme Court agree.
Okay.
All right.
Well, I think we'll close down now. So thank you everybody for attending, and if you want to watch it again, it will be on our Landlord Law YouTube channel in due course. Okay. Brilliant. Then, thank you everybody. Bye bye.